let's go to agenda item number 3, which is approval of minutes from the May 2nd meeting.
Item number 3, approval of minutes, May 2nd, 2012, record.
Madam Chair, I move to continue the minutes to next month. The reason being there are a number of corrections that are necessary, including some that are substantive. There are some misspellings in there of people's names. Also in items 6, 7, 8, and 10 of those minutes, there are discrepancies between the number of aye votes and the names of the members of council.
I'll second.
Is everyone pretty much in agreement? I think the majority has it. So why don't we continue as Member Nee suggested? Made a motion to continue items 3, 4, 5,
Public comment?
and 6. Right?
3, 4, 5.
Oh, I'm sorry, 3, 4, and 5
Public comment?
until the next meeting.
Public comment?
I don't think this is just an action item, so it's just a substantive issue.
No public comment. Okay, thank you.
Not on this one. Thank you.
I'm sorry, public comment on this substantive matter?
No,
Madam Chair, the only item that was on the floor was item 3.
oh, you didn't. I'm sorry, misunderstood. 3, 4,
What I
and
said
5.
was I moved to continue item 3.
Okay.
I think, I think items 4 and 5 also need to be continued, and if someone wants to, well, somebody might make a friendly amendment. I'm not sure it would be legal because items 4 and 5 have not been called by the clerk, but for the moment, my motion is strictly for item 3.
Member Philpo?
I would move to amend with unanimous consent of the members to add items 4 and 5, to call items 4 and 5, and to take a short amount of public comment before taking action.
So the motion on the floor is by Member Nee is to continue item 3, which is fine. You can vote on that. Vote on that. Oh, it's unanimous. That's fine. Then I can call 3 and 4 together. Then you want to vote to continue those and continue those the next meeting.
4 and 5.
I mean, yes, 4 and 5.
Whatever we do right now.
Through the chair, the minutes of the action of the task force or any public body is a requirement under the Sunshine Ordinance that they be taken, and the minutes are required to accurately reflect the action that was taken at the meeting. Given the importance of those requirements, I would advise that this is a substantive action by the task force, and public comment should be taken on these matters.
So are we taking public comment on the changes that the public wants to do at this time, or can we, that's what I was hoping to move till the next meeting when we do bring this up again, that we at that time can then take public comment for the actual changes that the public might have for the minutes.
This is about moving it.
The requirement that public comment be taken is in regard to any item on an agenda that is a substantive matter. So it's on the agenda item itself. Whatever motion the task force may make, it may differ from item to item, and you may have different motions on any agenda item, but the public comment has to be taken on the agenda item itself before action is taken.
Okay. Okay.
So can we amend memories, friendly amendment from item 4 to 5?
Through the chair, there's only one item that has been called by the administrator, and only one motion is on the floor. You cannot amend an item to include other items that have not yet been called.
Okay. So, Madam Chair?
Yes.
Can I suggest to Member Nee to withdraw the motion, to then call items 4 and 5, and then restate the motion to include all 3 items, and then we can take public comment and move on?
Who seconded the motion?
I did, and I will consent to what I just.
Okay, if you withdraw your second, and I will withdraw my motion.
Done.
So, do you wanna redo your, 3.5?
You can call multiple items without public comment in between. I thought he just said you had to have public comment for each item that was called.
So I've called item number 3, so 4, and then item 5. Item number 4, approval of minutes from the June 6th regular meeting. Item number 5, approval of minutes from July 11th, 2012 special meeting.
Madam Chair, I move to continue all three items, reason being that there are a number of errors in all of them.
Nice.
Second.
Is there public comment about the minutes? Anyone would like to speak?
Yes, Peter Warfield. First of all, these are three items, and I hope you will give 9 minutes to members of the public if they wish to have it. I don't think it'll take 9 minutes, but I certainly have prepared some comments on this, and I think it's very presumptuous to the public and rude to assume that those of us who come to this or that meeting will naturally be coming to the next one and the next one and the next one. There may be other things that people have in their lives, and they may have prepared some material, and as your attorney said, wish to have those things heard so that you can, if necessary, consider those next time when you meet, perhaps without that member of the public. So I'd first of all like to know if you're going to give 9 minutes to the public.
9 minutes to each person?
That's right.
Unfortunately, I can't. But I will give you 3 minutes, a minute for each agenda.
Okay, well, I think that's highly inappropriate.
Mhm.
As you heard from your own attorney, it's a substantive matter, and to chop public comment down to 1 minute per item, I think is highly inappropriate. So the first thing I want to say is that in general, I would agree with Member Nee that it would be fine, and I would support the postponement of action on these, but not comment. On the May 2nd meeting minutes, item 2, well, first of all, I'd like to also say I'd be very interested in what Member Nee's objections are. They may completely coincide with mine and other people's, so that we don't even have to say anything. I think it would be very appropriate that those changes not be made, basically in secret through some administrative backroom arrangement. I'd like to hear what those concerns are. On item 2 of May 2nd, Peter Warfield spoke expressing objection with the report. I had a very specific reason for being concerned about the report and what the task force was doing about it, its failure to check. And my recollection is that as in previous years, the supervisor of records report did not show the date of receiving a request so that you could compare it to the date responded and see whether the city attorney was fulfilling the legally mandated requirement of a prompt response within a certain fixed number of days as required by the ordinance. On item 4, page P9, the second page of May 2, Peter Warfield spoke in support of not having a statute of limitation. I think that's a very sketchy, which is to say extremely brief thing. I expressed particularly concern that people may not even know there has been a violation until some time has passed, and to provide a statute of limitation would be favoring wrongdoers, so that if they could hide their wrongdoing from the public, they could get away with it if they managed to do so for a certain amount of time. There are many other issues that I have with these minutes that I think you should fairly listen to, so that you can combine these comments, if you wish, with those that perhaps Member Nee might have. I think item 5, the summary of what I said is just wrong. On item 7, I think there could be a little bit more explanation about what the complaint was. On the June 6th minutes, I think there could be some improvements about summaries of what people said on item 1, on particularly on item page 3 of those minutes. And to hurry ahead, there are some very simple details that I think would enhance these minutes on page 2 of July 2nd, for example, on item 1. And that's all that I have for now. Thank you.
Thank you.
Hello, once again, my name is Jason Grantgars, and I've been before this august, robust committee, and I'm a little, concerned. I mean, Mr. Nee now says that, you know, he wants to withdraw some things from the agenda. Hasn't it been 5 months since you guys basically, like I said, were in a nuclear winter? Nothing was done in these 5 months, you know, to bring things forward, which brings up another interesting question. What were the victims supposed to have done for these last 5 months? I know that I personally had communications and sent stuff into the Sunshine Task Force, but, you know, as many years as I've been here, those things are never answered. The process, the procedure is never followed up with.
Point of order, Madam Chair, the speaker is not arguing, is not commenting on the motion that's before us.
Once again, I totally disagree. You know, the whole point is I'm here to admonish the fact, like you said, Mr. Nee, that there are things that are wrong. I'm saying, what about the 5 months? So your corollary, trying to say that it's not on the agenda, is a total mislead and misrepresentation in my mind.
We're talking about the minutes for 3 meetings.
That is correct, and that could not have been brought up in the last 5 months of your failed Ministry of Sunshine. That couldn't have been addressed as when we got here. We could move forward. It's a simple question that I think reasonable people would ask of such learned individuals. Thank you.
Can we,
Ray Arts, Director, San Francisco Open Government, and I want to say that first, we have never directly stated whether we're doing the 2-minute, 3-minute, whatever, because the last few times you've met, it's been cut back, and you know, for this reason or that reason, to 2 minutes. And I think it is very important to clearly let the members of the public know the length of time they have to talk. As far as the approval of the minutes and the motion to continue them, I believe it is a very appropriate one. I've spent the last 2 years talking about minutes from not only this body but other bodies that did not accurately reflect what members of the public had to say. And in most cases, it was an issue of they didn't like what was being done, and as a result, their comments were censored. And even though the Sunshine Ordinance, and I've gotten multiple rulings from this body to it, says that if a person wants to submit a 150-word summary to be included in the minutes, to ensure that their comments are accurately reflected, because they are free speech, and that free speech right extends to having those, especially in a public meeting, accurately reflected. I think that the simple fact that Mr. Nee has brought brought to the attention of the body that these minutes are not do not accurately reflect it. I thank Mr. Threet for his comment saying that that's an important criteria. Having the minutes accurate is a critical thing, especially having people who have disagreements with how things are being done, so that it just doesn't look like nobody brought up these points. One of the reasons I have been very adamant about the part of the Sunshine Ordinance that says if I want to submit a 150-word summary of my comments, that it be included in the body of the minutes is critical, because the Brown Act specifically states that you can't suppress unpopular comment. And unfortunately, throughout this city, I go to a number of meetings where people who get up and express comments relating to the operations or the handling of certain things get their comments censored.